Uh, a very good afternoon to one and all present here, to all the listeners. I am Ms. Chinki Verma, Assistant Professor, IIMT College of Law. The topic I'll be discussing today is theories of punishment. So, before directly proceeding with the theories of punishment, first we need to understand the basic concepts like what do you mean by the term penology? Now, the term penology in basic sense means the study of punishment in its relation to crime. It is the body of systematic knowledge of management of penal measures and institutions. It is basically a science which deals with principles and methods of punishment. The term penology is a lot of times confused with the terms like victimology, criminology. However, I would like to clarify here that all these terms are very different. The term criminology means the science of crime. It includes within its scopes the meaning of crime, the causation of crime, why do people commit crime, what are the procedures that could be taken to deal with these criminals. So criminology is basically a lot wider in scope than the term penology. Penology only deals with the theories of punishment, the objective of punishment, meaning of punishment, and various other concepts connected with punishment. Victimology, on the other sense, is the science which is related to the study of retribution and the catering the needs of victims. Now, penology, uh, the term penology was coined in 1984 by Francis Lieber. Francis Lieber is a criminologist who defines penology as that branch of criminal science which occupies itself or ought to do so with the punishment and the criminals, not with the definition of crime, which belongs to the criminal law and the penal process. So, in this definition, Francis Weber clearly demarcated between the two terms, criminology and penology. Criminology is concerned with crime. Penology, on the other hand, is concerned with the situation after a crime is committed. That is the punishment part, which is a post-crime situation. Now, this term penology was also defined by the criminologist Fairchild. Fairchild defines penology as the field of applied sociology which deals with the theory and the methods of punishments of crime. Dean J. Champion defined this term as study of theories and practices of punishment. What is common in all this definition is that repetitions of that the phrase theories of punishment is repeated n numbers of times. So this creates a belief that the concept of theories of punishment is very important for for understanding the concept of penology. Now, penology basically is the systematic study of appropriate sentence on the conviction of an offender and the execution thereof in the form prescribed by law. Now we know even jurists like Austin also says that for any law to be implemented, to be implemented, sanction plays a very important role. Sanction is a tool of control in the hands of the ruler or the state, whichever is the situation. Now, a law where there is no provision for sanction is worthless because we don't have any tool, we don't have any instrument to punish the people who go against the law. So, in such situation, it clearly highlights what important role punishment play. So, before proceeding with and the types of punishment, we need to understand what is the objective of this punishment, what is the main goal that we are trying to achieve with the help of punishments. So there are basically four theories of punishment which according to them give different objectives that punishment aims to achieve. These four theories are first the different theory, second the retributive theory, third the preventive theory, and fourth one, which is the theory we are currently applying in all the criminal in most criminal justice system, is the reformative theory or rehabilitative theory. So first we need to start with the main theory which has the more number of followers, which is deterrent theory. As the name signifies, this theory is basically aiming at deterring or making a fear in the minds of the criminal. This theory aims to set an example in the minds of the criminals that yes, if you commit such type of criminal activities, if you go against the direction of the state, If you go against the interest of the society, you will be punished, and such punishment will be so harsh that no other person will be thinking about committing the same criminality. This is the reason such type of punishment are also called exemplary punishment, because example is being set up. Here, severe penalties are used to deter the criminals from committing any criminal activities. The founder of this theory is Germany Bentham. According to him, as we all know, if we have studied even the basic concept of jurisprudence, we know Germany Bentham is a utilitarian. He gave the utilitarian theory of jurisprudence. What does this utilitarian theory say? This theory says that the aim of the law is maximum good for maximum number of people. Now, how will we achieve this maximum good? We'll achieve this maximum good if or this small portion of people who are going against the state, who are going against the law, are punished very harshly, that even that the next person, any person who is thinking about committing any criminality, is deterred from such activities. Now, following the same principle, different theories want to give harshest possible punishment to the criminals. For example, if this theory is still followed in some uh, Muslim nations, some Islamic nations, like in a very classic example of such theory will be uh, what happens is if you steal bread. Now, what type of crime you have committed? You have committed theft. Now, theft is comparatively a very petty, a very trivial crime as related to murder or rape. Such crimes are very like the amount of gravity in such crime is very more much larger than the crimes like theft. Now, in this, now what does this difference theory say? Now, this theory says that even if a person is committing a very trivial crime, a very petty crime like theft, even but what does the state want? The state wants that the citizens don't even commit such petty crimes. So to deter these such petty criminalities, to create a fear in the minds of the people, even for such petty crimes, harsher punishments will be implemented. Like for example, the hands of the theft will be chopped off. Now, are these theories proportionate? Like, are you giving the proportional punishment? One of the basic principle of criminal law is that the crime and the punishment should be proportional. The punishment should be in accordance with the crime. If the crime is a very grievous one, the punishment should be harsher. And if the crime is not so grievous, the punishment should not be harsher. So, what are the ill consequences of this theory? First and the foremost ill consequence of such a implementing such a theory is hardened criminals. Now, who are hardened criminals? Hardened criminals are the repeated offenders who has like who are recidivist. They are committing crime yet again. They have once been already treated for the criminality. They once have been already gone through the ill consequences of criminality, but still they are not reformed by the law. So theories like different theory are not able to deal with such type of criminals. Now, the other theory I'll be talking about is retributive theory. Now, retributive theory, as as the name signifies, for every theory we first need to analyze the name of the theory itself, because a lot of the answer is in the name itself. So, retributive theory means to retribute. It means to equalize. For example, this theory says that evil should be written with evil. If you commit an act against me, I'll commit the same act against you. This theory says what it like. If we go for simple English, like tit for tat. If you do this, I'll do the same. This is what this theory says. If a crime is committed against you, the law should be empowered to help you, or to either allow you or help you to commit the same act against the accused. Now, this theory is based upon the idea of vengeance. This theory, for example, if a person has killed someone, then according to this theory, the most appropriate punishment will be killing that murderer. Like if you have killed someone, you commit murder, you'll be treated similarly, and you will be executed by the state. Now, we of course we do allow death penalty in the cases of murder, but not all the cases of murder should be dealt similarly. Not all the cases should be treated similarly. Like there are various circumstances. Like let's say the murder is committed by a woman to save herself from rape. Now, this is a clear case of private defense. Now, in such a cases, will it be justified to awarding death sentence to that woman? Of course not. So we cannot like treat every case similarly. This theory of vengeance fails on this point. Even now we are Indians. For this theory, I would like to quote Gandhi. Gandhi says, "An eye for an eye will make the whole world go blind." That means if you treat the same criminality with you've written the criminality with criminals, you will also be a criminal. You won't be you won't be a law-abiding citizen if the law allows you to take vengeance from the criminal by doing the same criminality. Now then you and that criminal will be no different, will be similar to him. So this is the point this theory is criticized on. uh, Emil Kant was the no the writer Emil Kant was the supporter of this theory. According to him, punishment is an end itself, but this point is a lot of time criticized because punishment is not an end. Punishment rather is a means to an end. Our main end is justice, ultimate justice, and punishment should just be a means to achieve that end of justice. You cannot say that you have punished a criminal, so you have achieved justice. No, you will not achieve justice unless and until that punishment you have inflicted on that accused is proportional, and as a result of that punishment, that accused is reformed. If that accused is not reformed, you cannot just give him the punishment for the sake of it. Punishment like these serves no purpose. Now, the other theory is preventive theory. So, preventive theory to prevent. This theory, this theory is also called incapacitating theory. This theory aims at incapacitating the offender from committing further criminality. Now, how do you prevent someone? How do you incapacitate someone? The most classic way of this is putting that person behind bars. Up now, if that person is not out in open, if that person is not living as a member of society, he is detained in a prison, that person cannot commit any criminality because he is not even in the society to commit any criminality. So this theory says that our main objective is to prevent the society from criminality. So the most easiest way is of this is to put that offender behind bars. If he is behind bars, he won't be able to commit any criminality. This theory, this theory promotes prevents doesn't prevent vengeance but to prevent. The main aim is to punish. The main aim is not to punish but to prevent. Prison institutions are based on this theory only. But now is this theory really good? What are There are many ill consequences of imprisonment also. For example, if a person is put behind bars for n number of years, now let's say he's behind bars for 20 years. Now after 20 years, if he is released from such institution, that person is totally institutionalized. He cannot be said to be a normal citizen. He cannot live in the society without the help of state now. Because he's totally, for the last 20 years he has been dependent upon the state for all his needs. He doesn't need to earn a livelihood. He doesn't need to provide for his family. He doesn't need to do various other stuff that a normal citizen has to. So in these past 20 years, he has been so much institutionalized that now he is incapable of living as a normal person. And another ill consequences or another criticism of this theory could be that if you incapacitate a offender, if you put a offender behind bar, it is not only the offender which is affected, but his family also. Let's say that the person you have put behind bars is the sole earner of the family. He's the sole bread earner. Now that a family of 10 person is dependent upon that one bread earner. If you put that bread earner behind bar, now will that remaining 10% in the family be able to survive? Of course no. Who will provide for them? No, they don't have another means of livelihood. They don't have another means of addressing their needs. So if you incapacitate, if you save the society from that offender by putting that offender behind bars, what about the other 10 people that are left behind? State is not providing for them. So who will provide for them? This is something which has to be considered. Now, apart from this, other criticism could be revenue. Now, if a offender is put behind bars, all the expenses, like for his fooding, clothing, shelter, everything is bared by state. Now, if state doesn't have a revenue of its own, state gets revenue from taxpayers' money. Now you are using the money of people, the tax money, to cater for the needs of the criminal. That criminal is this criminal is that said person who has committed a wrong against society itself. Now you're using the money of the victim to address the need of the culprit. Is that right? Of course not. You are using the taxpayers money to provide for the needs of that accused, that not even accused, that convict, that has committed an act against the interest of the victim itself. So these are some points on which this theory is criticized. Now the last theory that I'll be discussing is the reformative theory. This theory is also called the rehabilitative theory. Now, uh, now in different theory, the main focus is on the crime. We are punishing the criminal according to the crime. But in this theory, the main focus is shifted from crime to criminals. Here, the punishment is not given in accordance with the crime, but the punishment is given in accordance to the criminal. Here, there's an individualized approach. We here focus upon the needs, specific characteristics of the accused, because here our main objective is to rehabilitate the accused, to reintegrate him as a law-abiding citizen, and not merely to punish him. So this theory stresses upon treatment and not punishment, and this specific treatment must be individualized. Individualized means every individual should be analyzed basis upon his own uh, unique characteristic, and based upon this unique characteristic you have to award the sentence which is best suited for that very criminal, because every individual is different. One type of punishment may be addressing the needs of a criminal, but that same type of punishment cannot be said to be addressing the needs of all the criminals. We need what we need here is individualized treatment. Here the theory this theory says that harsh punishment, capital punishment are punitive, unjust, and inhuman. For example, like, what is capital punishment? Capital punishment is execution, death penalty. Now if you execute someone, if you hang someone, if you take someone's life, that person will not be living to be reformed. If that person is not living, you cannot reform him. So this theory is against harsh punishment, capital punishment, because this theory believes in giving a second chance, giving a chance of reformation. This state believes in innate good nature of the human being. This theory believes that every person, even if that is an accused, should be given a chance to reform himself. This story believes that this theory believes that the main reason a person turn towards criminality is because the state is unable to provide for his needs. And if the state is unable to provide for his needs, it is the state who have to take the responsibility to reform him. So state, instead of punishing him, should treat him. Here that, for example, we could relate this theory to a patient. This theory sees that particular convict as a patient which needs treatment. Now, what that treatment will be, this treatment will be dependent upon the specific needs of that accused. If then accused is a drug addict and that accused commits a crime, let's say he commits theft to procure money for buying drugs. So the in such a cases, the main object if our main objective is to reform that accused, instead of awarding him punishment, instead of awarding him imprisonment, we'll award him de-addiction services, because what he needs uh, at this point of time is de-addiction services. Because if that drug addiction is removed from him, he'll be reinstated as a law-abiding citizen. This theory this theory believes in social reintegration. This theory believes that if sufficient opportunities are given to a citizen, he can be adjusted to the life in out and open. He could be given a life out of jail, he could live as a law-abiding citizen and actually be an asset for the nation instead of being a liability. This The concept of parole probation is based upon this theory only. Now, what is a clear differentiation has to be drawn between the concept of parole and probation. Now, parole is an after conviction process. It is now parole is not given by court but the jail authorities. Parole is some kind of leave from the jail sentence where the accused is given some days off from the jail. He is let out in the open to attend some, let's say, some important family functions like marriage, or he could be given these leaves to attend a death ceremony of his father or any other relative. He could be given this leaves even uh, to attend uh, to attend important functions. Look, there's no exhaustive list, but illustrative list. Now, now the parole authorities or the jail authorities, depending upon the specific case of that accused, that convict, can award him parole. In such period of time, that accused will be that convict will be let out from jail. He'll be let out in the open. He'll go into society, meet his near and dear ones, and like he'll be able to establish a connection with the society, so that when after serving his sentence, let's say after 2 years or 3 years, whatever the sentence is, after serving his sentence to the fullest, when he's let out in the open, he's able to reintegrate in the society as a law-abiding citizen and is not institutionalized. He's not dependent upon the state, but even outside the jail institution, he maintained an identity, he maintained some ties. Similarly, probation on the other side is a bit different from parole. Parole is given to an accused by the jail authorities when he is sentenced, when he is suffering his sentence of imprisonment. Probation, on the other hand, is given by the court. It is also a post-trial procedure. In this case, uh, 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 a convict when he is brought before the court, and court analyzes factors like the age of the accused, type of crime he committed, antecedents, his previous character, such other circumstances, and he sees whether that accused should, instead of being awarded imprisonment, he should be let out in probation. Now, probation is dealt under uh, section 360 clause 1 of CRPC, and for this we even also have a specific act of probation of offender act 1958. Now, this act provides this specific condition which the state in which the court is empowered to award probation instead of imprisonment sentence. In probation of offender act, we even have a specific section, that is section 6, which provides that if the offender is below the age of 21 and the crime he is convicted of is not punishable with death sentence or life imprisonment, in such a case the court should, as a rule, award probation to that accused, that convict. And if that court consider that no, that convicted should not be let out on probation, instead he should be sent to jail to suffer his sentence, in such a cases that court is liable to record his reason in writing why such particular offender is not given probation but instead detained in jail. Apart from this, the whole juvenile justice system is based upon this reformative theory itself. The juvenile justice system provides a different procedure for dealing with juveniles. The punishment they could be awarded is totally different. The procedure they are dealt with is totally different from adult offender. For example, the Juvenile Justice Act 2015 provides that the maximum sentence that a juvenile justice board can award juvenile is 3 years. After 3 years, that particular juvenile cannot be detained, and even in this period of 3 years, he will not be detained in a prison. Instead, he will be put in an observation home, a special home, where where the authorities will be focusing on rehabilitating that particular juvenile, that particular child, uh, to a law-abiding citizen, to they'll be focusing on correcting his criminalities. In though there has been certain change in the juvenile justice system after 2013, 2012 Nirbhaya case, which brought 2013 Justice Verma Committee. Based upon this, we have now released the Juvenile Justice Act 2015. In the Juvenile Justice Act 2015, as differentiated from the 2000 Act, here we do have a provision for treating that accused as an adult. For example, the Section 15 procedure provides that when if the conditions of Section 15 are fulfilled, that particular child will that particular child in the age gap of age group of 16 to 18 could be dealt as an adult offender. Now, this is a different thing. This is this particular part of Juvenile Justice Act could be said to be going against the Deformative Theory, but still, the major part of Juvenile Justice Act is based on this Deformative Theory only. This theory uh, this whole system of treating a juvenile as a different personality, as a different offender from the adult offender, is mainly based upon the objective of treating that offender and not treating that juvenile and not punishing him. Here we are providing for individualized treatment of that particular juvenile so that his criminal ways could be treated and he could be established as a law-abiding citizen, and his recidivist tendencies are addressed. Now, what does recidivism mean? Recidivism means reoffending. A person who has once been treated for the ill consequences of criminality commits criminality again. Now, the whole concept of recidivism goes against the objective of crime, objective of law. The main objective of law is treating an offender, and if an offender is turning his way, is going towards the way of criminality again, then this whole objective, this whole process of law fails. So, to summarize this, what I would like to say is that the newest theory, that the theory which is currently most popular, is the reformative theory or rehabilitative theory. Now, most of the laws are being based upon this theory. It is because of this theory that newer form of punishment like community sentence, fines are being introduced, because now we are focusing upon the treatment, the rehabilitation of the accused rather than on punishment. Uh, Even India also is turning towards the same way. In the near future, we can expect new types of punishment based upon this theory.